the rules. We take the case, they're established. And the first case is already teed up, so let's go to the appellant. That's a Drysdale and Washington Savings case.
Good morning, your honors. May it please the court to reserve 5 minutes for rebuttal as well.
Let me do me one thing. I'll try speaking for my thing. If you do the same for me.
Is this better?
Okay.
Yeah, okay. Good morning, your honors. My name is Ryan Fogle. I am the attorney for the appellant Laura Drysdale.
It's starting the clock now, just so you know. I didn't take that time off when you was bantering.
Somebody said, I appreciate it. Thank you. Your honor, my name is Ryan Fogle. I represent the appellant Laura Drysdale. Ms. Drysdale.
What's your name again?
Ryan.
Okay, just kidding.
Ms. Drysdale lost her partner of 8 years in 2020. Two of them owned a motorhome or motorhome or an RV.
Oh, summarize the gist of your main issue. Is it she claimed Homestead? She didn't claim Homestead. She claimed the mortgage gave her the right to intervene.
That's correct, your honor.
She is the necessary party, an indispensable party.
That is correct, your
And the
honor.
judge views his or her discretion in denying the motion to intervene.
Her signature was on the mortgage, but not the note, all right?
That is correct. It was on both the
What is she indispensable?
well, her rights are directly affected by the outcome of this matter. Well, as a result of it, she's had to leave the property. She no longer has access to this mobile home any longer. She now had to move to Indiana with her sister.
So what right did she have to live in the home to begin with, other than her former husband's, I guess, kindness in letting her live there?
Yes, your honor. She had and her husband made that place a home. She invested.
Signature on the mortgage, that alone would give her a right to the property.
Her signature alone would not, but her possession created the beneficiary interest. She had a contract interest in the property because she was still.
Because she had lived there for a while?
Well, because her name was on the mortgage. It was both on the mortgage and the modification, which modified it, therefore creating a legal right in that property. Because she had a right that needed to be, she had that mortgage created the right of redemption. The right of redemption is a right that grows naturally out of a mortgage.
And you can only redeem the property interest that you've already had. So what is the property right, the property interest that she already had? When her former husband was the only one named on the note and the only one named on the deed.
It's a little stretched, your honor, and we can see that, but this is also where it arises, that the mortgage, which creates secures the indebtedness on the property, she agreed to it. She was agreed to as a mortgagor. She had then again, we're staying with the possessory right as a mobile home. She had possession of the property. She approved the property. She invested in the property. She created a beneficiary interest in the property, same as a tenant and a landlord. She had that interest. As a result of the mortgage being removed from the case, she lost her ability to fight for even the right of redemption, which is still an equitable right granted to her by just being on the mortgage alone.
But again, to redeem what? To just continue living on this property that she doesn't own just by virtue of the fact that she was allowed to live there for some period of time previously?
Yes. Yes, Your Honor. She has that right as a result of being in the property, as a result of being somebody who has signed her name to a contract, agreed to be a mortgagor in the property, and then moved forward as the property. She would have been able to move for a modification had she been considered a person, or even a refinance of the property had she been considered a party in this case. She has that legal right through the mortgage.
But to what end, I guess, is my point. I mean, the mortgage just sets forth the terms for paying off the debt that's secured by the note,
So,
right?
so it'd be up into the terms of the note that was signed by her now deceased ex-husband.
So because she agreed, I just want to make sure I understand, because she agreed that she might be on the hook. And I'm not even sure if she really agreed to that, because if she, the loan modification agreement doesn't actually list her as the borrower. She may have signed it, but the loan modification that followed from the mortgage didn't actually list her as a borrower, I don't think.
No, it did. I do believe it did define her as a borrower under the modification.
The loan modification agreement is effective March 1st, 2017 between Kip Drysdale and the servicer acting on behalf of the lender. She is not named, even though she has signed the document, she is not named as a party to the loan modification agreement. What is the relationship between the loan modification agreement and the mortgage modification agreement?
The loan modification agreement is the mortgage modifications.
No, I've got two separate documents here. One says mortgage modification agreement, and the other says loan modification agreement. So what is the relationship between these two?
Your Honor, I have there's a loan modification agreement, or the mortgage modification. This is the one that was entered on September 7th, 2017.
It was the mortgage modification agreement is effective as of March 1st, 2017. That was at page 52 of the record. The loan modification agreement was at page 61 of the record, and it was also effective March 1st, 2017.
I have an answer for that, Your Honor. I don't.
You'd be arguing that because she lived there for a period of time, it gave her some ownership interest.
It gave her a beneficiary interest in the property to at least allow her to stay within the case. The issue is that this woman was removed from the case and lost all arguments as a result of being considered not a necessary and indispensable party. And our argument is that she is at least there to have her voice heard as far as it's concerned within the foreclosure argument. She was living there. She was a possessor of the property. And to some extent, she had signed the modification as well as the original mortgage. Now, the mortgage, I concede, doesn't grant the interest in and of itself, but it does still create an interest in an equitable right that is affected by the mortgage process, the foreclosure process.
Curious, are you saying that trial court had no choice but to grant the motion to intervene as a matter of law? Or the trial court had discretion to grant or deny?
Yeah, I believe as a matter of law, she was a party. She was a party to the
What's the
case.
best case you want to cite for that proposition?
Your Honor, I would cite to the Sudoff case, which is Sudoff.
Okay.
It's versus Fannie Mae, 942 Southern 2nd, 425. And Your Honor, that case is similar to this matter in which there was a woman who was on the mortgage, not on the note or deed. And she was dropped as a party, but she was then
Not on the note.
not on the note. But because her equitable right of redemption was affected by the outcome of the foreclosure matter, she therefore had at least an interest in the outcome of the case.
Wasn't she still legally married to her husband? So even if she wasn't named on the note, they were still legally married, weren't they?
Yes, they were. Your Honor. But again, and I stand on this, is that the mortgage modification, at least as it's written, is not as a husband and wife, but as a joint tenancy. It is not the same as if they were still by the entirety. She still has an independent right that was created out of this mortgage, this right of redemption. And then so
So she basically stands in the shoes of like a junior lien holder, and I just don't, I'm trying to figure out what you're equating her right to.
She would have the right of tenancy under the half interest in the property. And when Mr. Drysdale passed on, it was her responsibility to assume the payments under the mortgage, therefore creating her interest. Again, our argument is not even so much as it creates into the foreclosure argument, so much as she was a necessary party that shouldn't have been dropped from the case. Didn't have a voice, lost her voice and the ability to proceed with this matter that affected her home directly, something that she signed for. She was on the modification. She was on the original mortgage. The divorce has very little to do with the effect of the case because it's not going through laws of intestacy and we're not going through.
Actually, one more question.
Sure.
Have you got any case that you want to cite from the second district court of appeal? Sudoff from the fifth. I think Sudoff had a different standard review on appeal. And they seem to find that it's a matter of discretion, of abuse of discretion, for not allowing the individual to join. I'm not sure you've got someone in the facts here.
No, Your Honor, I don't have a case from the second office, but
All right, that's fine. You got 9 minutes to go, so you have plenty of time to finish up. If you're not, if you want to stay, do you want to stay 5 minutes till we vote or something else?
yeah, I'll just I'll stop here and reserve the rest for rebuttal.
Good morning, Your Honors. Brandy Wilson for Kelly Wilmington Savings Trust. Your Honor, it is the appellee's position that under Florida Statute 697.02, the language is clear that a mortgage cannot create either a possessory interest or an ownership interest. So that would mean that without signing the note and without being on the deed in her own name and without being married, the appellant had no possessory or ownership interest in the
He
property.
cites Sudoff, a 2006 case out of the fifth, almost 20 years old.
Correct.
What's your response to his saying that's authority?
Under Sudoff, the parties were still married, and so because they were still married, the court found that intervention should have been permitted, and the issue of whether she still had a homestead interest would be adjudicated. The case specifically states that they are only ruling on the intervention, and they are not ruling whether she has an actual interest. But because they are still married, there's a presumption that she still has that constitutional homestead protection, and that they must go to a further hearing to determine whether or not that exemption applied, but she still gets to make that argument. The court in Sudoff found that the wife had been stripped of her due process right of redemption unnecessarily by the court. Here, Wilmington did not.
Because the standard seems like it's abuse of discretion under those circumstances. He said it's a matter of law, she has the right to begin in this case. Your response to that?
I would absolutely disagree, and it's the first time hearing of this because the initial brief even stated it was an abuse of discretion standard and cited the case law to it, and we agreed to it in our answer brief as well.
Gotcha.
But in Sudoff, the court found that that the redemption right was extinguished without due process, and that was correct in there because the parties were still married. Here, the appellee did not extinguish the due process rights, the divorce decree did. So that divorce decree in 2014 extinguished the spousal interest, which was admitted to in the memo. We cite to it in our answer brief that the appellants clearly stated that the spousal interest was extinguished with the divorce.
So what legal effect does it have that she signed the mortgage modification agreement? You could go after her for a deficiency judgment?
No, we cannot.
You can't go after her for anything?
No, we cannot.
So she has no exposure.
Correct.
So why would she have signed it? I mean, I know it's not necessarily in the record why she signed it, but what are reasons that somebody would sign a loan modification agreement or the mortgage modification when they don't have a possessory interest in the property?
If they're still holding themselves out to be the spouse. And here we believe that was the case, as the filings state that they are spouses in the case, and also the coroner, the death certificate, she stated she was a spouse. This was not uncovered until the guardian ad litem report showed there was no remarriage, and we held a deposition to point blank ask the question.
Can you explain the relationship between the mortgage modification agreement and loan modification agreement?
Yes, that confused me as well. So the front page where it lists the full trust name, that is more of a recording page and acknowledgement, and it states that attached as an exhibit is the actual modification with the servicer, SPS. And so that is attached along with the cover letter from SPS, and it does state that the borrower as the only individual. There's no type space for the for the other person, Ms. Drysdale, to sign. It looks like she did sign it, but it does look like that cover page is just an affirmation.
Okay. Thank you.
Once the divorce became final and stripped her of the interest for the homestead, that's where we differ from the Sudhoff case. And the other cases that were cited in the briefings involved someone who the spouse was either still on the note or was on the title as well and had a liability. Here, we have already entered the NREM final judgment. No one's coming after her for the money as she did not assume the liability. And one more thing, just a moment. But I'll just end with under 697.02, the modification just can't create the ownership interest here. And an indispensable party, as cited by the case law, is a party who has an ownership interest. And here she doesn't have that. A necessary party would be one where the judgment, there'd be a cloud on title if they were not named, and more like a junior lien holder, as was mentioned. But here she doesn't have any junior lien interest. So under that, there is no interest. It was extinguished by the divorce. And so she's neither a necessary or indispensable party. And I will cede the rest of my time for any questions.
Appreciate that. Thank you. Is it Mr. Bojo or Coho?
Oh, Your Honor.
Mr. Coho, come on up. You want 5 minutes? You got 5 minutes if you need it.
Your Honor, I don't. I think what was said and what is in the briefing stands on its own. So unless there are additional questions, I will concede my last 5 minutes as well.
Appreciate you can. Thank you.
Thank you.
We'll pull the next case.
Thank you.
We need a benchmark case versus State Fund Insurance Company.